And with that, I would like to introduce our very own Brian Polinsky to talk about local model bylaws. Brian, take it over.
All right, thanks, Peggy. Good morning, everyone. Thanks for joining me today to talk about the California Model Local Bylaws. This is going to be a very straightforward session. What I want to do is basically put up the model bylaws on the screen, and we're going to go through it from beginning to end. And I'm going to talk about the sections that NAR requires you to adopt verbatim, and I'm going to talk about all the other sections, which are really just best practices, things that C.A.R. recommends that local associations have in their bylaws. Many local associations simply choose to adopt the California Model Local Bylaws wholesale, but plenty of local associations like to make their own changes, and you can do that, but I'll talk about the reason that we have the various provisions that we do in the local bylaws. So I'm going to share my screen right now. All right, so let's start at the beginning. These model local bylaws were last edited in February of this year. We have an intro section in the model local bylaws. I'm guessing a lot of times people just skip over it, but if you're not familiar with the model local bylaws, it's useful to read this section to kind of understand what they are. So in the intro, it says that the California model bylaws are designed and intended for use by member associations in California, and they're drafted to be in compliance with the policies of NAR and also California state law. And as I said, some associations, they may want to adopt different bylaws or make minor revisions to them, and that's totally okay. You can do that. But if you do that, it is a good idea to have any changes that you make to the models reviewed by your own counsel. And if you are making changes that affect some of the NAR mandated sections, you can get them approved by NAR. For most of the changes that you would probably be making, NAR doesn't approve of them. Now, while NAR formally required review and approval of all bylaws, as of 2018, NAR no longer actually looks at the entire bylaws of each local association. What you do instead is you fill out a certification form annually to certify to NAR that your bylaws contain certain core NAR mandated portions. So there's actually a form on the NAR website that you have to fill out and certify that your bylaws contain those portions. Now, the C.A.R. model bylaws do have these NAR mandated provisions. So if you have adopted the C.A.R. model local bylaws, then you'll be fulfilling the NAR requirement. So this next paragraph talks about the portions of the model local bylaws that NAR requires you to adopt verbatim, in other words, word for word. So if you ever are curious or don't remember what sections of the model local bylaws have to be verbatim, it's included in this section. And like I said, we're going to go through all of the model local bylaws, so you'll see what each of these sections involve. These are the articles that must be incorporated into a member association's bylaws. Sometimes I get questions about whether verbatim adoption means actual word for word adoption. I actually just today got a question about that. There was one association that was going through their own bylaws in an effort to make them gender neutral in every way. And the person who asked me the question noted that there were a couple of references to he or she in the verbatim sections, and they wanted to get rid of those pronouns. I said, that's totally fine, because if you're making that change, that is a non-substantive change. You're just changing the pronouns. So it's okay, you'd still technically have verbatim adoption, even though it's not word for word. So this paragraph kind of explains that. Well, word for word adoption ensures compliance with NAR policy. Minor revisions to the articles can be acceptable, like the pronoun example. If you ever have any questions about the model local bylaws, you can always ask C.A.R. and you know, specifically just ask me. I think most of you have my email and my phone number, and if you didn't, I'm always happy to share them. And I answer questions about the model bylaws, and for those of you who are new, I also am involved in professional standards matters, disciplinary and arbitration matters. So if you have questions about those things, you can always contact me as well. All right, next section is labeled important. Some additional things that you need to know about the model local bylaws. There are, every time we publish the model local bylaws, there are changes that are made, and those changes are going to be in red underlined font. This most recent version doesn't have a ton of changes. The things that we changed in this version of the model local bylaws were NAR mandates. So there was a change to incorporate new language mandated by NAR regarding the obligations of realtor members, and we made a change related to the definition of good standing. And so you'll see those as we go through the model local bylaws moving forward today. All right. So in order to adopt any or all of the changes set forth in this revised model, your association still will be required to follow its current process for amending the bylaws. So under earlier C.A.R. model bylaws in Article 15 on amendments, there were some NAR mandated provisions that could only be adopted by the board of directors, but all other changes needed to be adopted by a vote of the membership. And there was actually a change that we made to the model local bylaws in November of 2018 that made amending the bylaws easier moving forward. However, to make that amendment, to change the section about amendments, you needed to use the old amendment process. So you'll want to take a look at your association's own local bylaws to make sure that you have the newest version of the amendment process. And I'll show it to you what it says later, but it's much better than the previous version. It makes amending things a whole lot easier. Let me bring, all right, there we go. Right, we already talked about NAR's bylaws approval process. You just certify. And finally, C.A.R. provides its model bylaws as an aid to member associations, but it's still highly recommended that you have your bylaws revisions reviewed by local counsel if you're going to be making any changes to them. And that's all for the prologue. Let's scroll past the table of contents and move into the actual model local bylaws themselves. So for your bylaws, of course, you'll fill in this blank, your association of realtors and when the bylaws have been adopted. Article 1 requires verbatim adoption, but it's pretty much just pro forma. The name of the association, and then the fact that inclusion and retention of the registered trademark realtors in the name of the AOR is governed by the Constitution and bylaws of NAR, because of course NAR owns the trademark realtor. So that's all for Article 1. It's not anything that you'll need to refer to. Article 2, objectives. This does not require verbatim adoption, but most associations choose to adopt these objectives essentially verbatim. But if your association would like to add or delete any of these objectives, you're free to do that. But just to go through what those objectives are quickly of the association, it's to unite those engaged in the recognized branches of the real estate profession for the purpose of exerting a beneficial influence upon the profession. That's basically the idea behind the association. Then we define the recognized branches of the profession. Also to promote and maintain high standards of conduct in the real estate profession as expressed in the Code of Ethics. C is to provide a unified medium for real estate owners and those engaged in real estate profession, whereby their interests may be safeguarded and advanced, to further the interests of home and other real property ownership, to unite those engaged in the real estate profession within the C.A.R. and NAR communities, to designate for the benefit of the public these individuals in California authorized to use the term realtor and realtors as licensed and prescribed by NAR. So these are all the objectives generally of the association, why it's organized, why it exists, and that's put forth in Article 2. But now we're actually starting to get to the meat of the bylaws, which is membership criteria. We're finally getting to a section where I start, getting questions about it. So let's go through this. The first 3 sections of Article 3, you do need to adopt them verbatim because it's based on NAR criteria for who's allowed to be a member of an association. So first of all, Section 1 talks about the association's membership in NAR and C.A.R. And it says the association will be a member of both of those organizations as defined by their governing documents. By reason of the AOR's membership in NAR and C.A.R., each realtor member of the association is also entitled to membership in NAR and C.A.R. without further payment of dues. So this is essentially the way that the realtor organization is structured. Members join through the local association, and then they pay their dues to C.A.R. and N.A.R. through their local association. And this section basically explains that. The association shall continue as a member of N.A.R. and C.A.R. unless by a majority vote of all its realtor members, the decision is made to withdraw. Hopefully none of you do that. Okay, so next, section 2, ownership and use of the realtor membership marks. The association recognizes that the realtor mark is the exclusive property right of N.A.R., and the association can only use the term realtor when it's in good standing with N.A.R. And if at any time N.A.R. doesn't allow the association to use the mark anymore, then you're prohibited from using it. Adoption and enforcement of the N.A.R. Code of Ethics, compliance with N.A.R. and C.A.R. governing documents and policies. So this basically says the association is adopting the N.A.R. Code of Ethics and agrees to enforce it among its members. And also the association and all of its members agree to abide by the Constitution, bylaws, rules and regulations, code of ethics and policies of both N.A.R. and C.A.R. This section is important because sometimes I get questions about section 4 I'm talking about. We have, these separate policies that are not included in the bylaws. Are they still governing the association? And the answer is yes, you can adopt a separate policy document that's not in the bylaws themselves. And this section basically governs that. It says the association may adopt any rules and regulations or policies as long as they're not inconsistent with the Constitution, bylaws, rules and regs, code of ethics and policies of N.A.R. and C.A.R. and also these bylaws. So I know a lot of associations have their own policy manual apart from the bylaws themselves, and you can do that as long as they're consistent with the bylaws and consistent with N.A.R. and C.A.R. policy. Jurisdiction, Article 4. So the territorial jurisdiction of the association as a member of N.A.R. is, and then you would include the exact jurisdiction description that was officially approved by N.A.R.'s board of directors. Section 2 talks about jurisdictional rights, and it basically says that territorial jurisdiction is defined to mean the right and duty to control the use of the terms realtor and realtors, subject to the conditions set forth in the bylaws and those of N.A.R., and to protect and safeguard the property rights of N.A.R. in those terms. One thing to keep in mind, and I have gotten questions about this occasionally, having territorial jurisdiction doesn't give you the exclusive right to have a realtor office in that jurisdiction. N.A.R. does allow other local associations to have satellite offices within your jurisdiction. So that's important to remember. All right, Article 5. Now this one is a big one. It's 11 different sections, and this is one we get a lot of questions about. So it goes to membership qualification, application, and acceptance. The first 3 sections here do have to be verbatim. So you do have to include everything in sections 1, 2, and 3 in your own local bylaws. First, we have section 1, which talks about the classes of membership. And these will be further defined in the next sections. But if they're realtor members, institute affiliate members, and then the rest. Actually, the classes of membership 3, 4, 5, and 6, the definitions of those are not required to be adopted verbatim from N.A.R. and from the C.A.R. local bylaws. So you could actually make changes to the definition of those membership classes. But for realtor members and institute affiliate members, those definitions are set. So let's talk about what the qualifications are for realtor members. That's going to be most of your members. So realtor members, whether they're primary or secondary, who are principals. So section 2.1 talks about people who are principals defined as sole proprietors, partners, corporate officers, or branch office managers of real estate firms. To be a realtor member, they have to have a current valid California real estate broker or salesperson license, or a California real estate appraisal certification or license. So someone who is an appraiser can also join the association as a realtor member. Next, they have to act as a sole proprietor, partner, corporate officer of a real estate firm or office manager of a real estate firm, acting on behalf of the firm's principals. So to join under the 2.1 status, they actually have to be essentially the head of their firm or an office manager of the firm. C, they have to remain actively engaged in the real estate profession, which is defined throughout these bylaws as buying, selling, exchanging, renting, or leasing managing, counseling, appraising for others for compensation, building, developing, or subdividing real estate. So pretty broad, engaging in the real estate profession. As long as someone is doing at least one of those things, they would be actively engaged in the profession. D, they have to maintain or be associated with a real estate office located either within the state of California or, and this is important, they can also be in an office, a state contiguous to California. There's only a couple of states that are contiguous to California, of course. That would be Oregon, Nevada, and Arizona. But for any of those states that are contiguous, they could be affiliated with an office in one of those states and still be eligible for membership of your association. And then finally, they must have no record of official sanctions rendered by the courts or other lawful authorities for violations of civil rights laws or real estate license laws within the past 3 years. Or number 2, criminal convictions within the past 10 years, where the crime was punishable by death or imprisonment in excess of 1 year under the law. So this word here is actually important, punishable. It doesn't necessarily mean that they were punished with imprisonment in excess of 1 year, but that the crime was punishable, that they could have been punished with that under the statute. So that's important if that subject ever comes up. I'm always happy to talk to you about that if you have someone who you find out had a criminal conviction and wants to apply as a Realtor member. We can go through it and see if the crime meets the standards of one that wouldn't allow them to be a member of the Realtor Association. So that's Realtor principles. Section 2.2 talks about Realtor members who are not principals, whether primary or secondary. For those Realtor members, they just have to have a current valid California real estate broker or salesperson license, or a California real estate appraisal certification or license. They have to remain actively engaged in the real estate profession as we defined it in 2.1. They have to be employed by or affiliated as an independent contractor with a Realtor member who meets the requirements in section 2.1 or a state contiguous to it. And they have to have no record of official sanctions rendered by the courts or other lawful authorities. So same, criminal aspect as for Realtor principals. And then 2.3 is a different kind of Realtor member, a franchise corporate officer. So this is a different criteria that allows someone to become a Realtor member, even if they don't necessarily have a broker or salesperson license in California. These are the only way that you can do that is if you're a franchise corporate officer of a real estate brokerage franchise organization with at least 150 franchisees located within the US. And so franchise corporate officers may or may not be licensed for California real estate broker or salesperson or appraisal activities, but because of their status as a corporate officer of a real estate franchise, they can still be a Realtor member even without that license. 2.4 talks about designated realtors. So every firm, according to the bylaws, has to designate in writing one designated Realtor member who is going to be responsible for the conduct of individuals affiliated with the firm and accountable to the association for all the duties and obligations of association membership. And it also notes here what can qualify someone to be a designated Realtor. It has to be the sole proprietor, partner, corporate officer, or an office manager acting on behalf of the firm's principals. What's notable here is that the designated Realtor doesn't necessarily have to be the broker of record with the DRE for the firm. They just have to fall within one of these criteria that are listed here. Section 2.5 has to do with association of choice. And it talks about primary membership versus secondary membership, something I will get questions about from time to time. So licensees who are affiliated with a Realtor firm may choose as their primary association any association in California where the firm maintains a designated Realtor. So basically, if someone is a salesperson, they have to join as a primary member a firm where an association where their firm has a DR. They can't join an association where the firm does not have a DR. For secondary membership, on the other hand, and a Realtor has joined another association as a primary member, may join the AOR as a secondary member, and there doesn't need to be a designated Realtor member of the association for licensees to select that association as their secondary association. So that's really the key difference between primary and secondary membership. For secondary membership, there's one thing I want to point out in the last sentence here. The conditions for secondary membership shall be no more stringent than for primary membership, and the privileges of membership shall be the same, including the right to vote and hold office. From time to time, I've heard associations say they want to block out secondary members from serving in elected office or for serving in leadership roles. NAR will not allow you to do that. Secondary members are full-fledged members of your association, and they're treated like all other members of the association. 2.6 talks about the fact that each principal of the real estate firm who's actively engaged in real estate in California or a state contiguous to that is required to become a realtor member if any other principal of the firm is a realtor member. 2.7, in the case of a real estate firm, partnership, or corporation whose business activity is substantially all commercial, only those principals actively engaged in the real estate profession in connection with the same office or any other offices within the jurisdiction of the association in which the firm's principals hold realtor membership are required to hold realtor membership. So this is kind of an exception to 2.6. If the real estate firm has an entity whose business activity is commercial, that's exempt from the requirement that all principals have to join the realtor association. All right, so that's it for section 2 here. Section 3 is about institute affiliate members. And these are members who are individuals who hold a professional designation awarded by an institute, society, or council that's affiliated with NAR. And these affiliations address specialty areas other than residential brokerage, or individuals who otherwise hold a class of membership in such institute, society, or council that confers the right to hold office. So if anyone holds those designations, they're allowed to be institute affiliate members. The next set of memberships, affiliate members, public service members, honorary members, student members, you're not required to adopt these definitions from the model local bylaws, although most associations do. I think the most common one that we see are affiliate members. These are usually members who are just people who don't qualify for realtor membership, but they still have an interest in the real estate profession. A lot of times they're vendors who want to be able to market their products to realtors, and they can join as an affiliate member in that way, and that's fine. But the important thing to remember is that the definition in the model bylaws for an affiliate member is it's someone who doesn't qualify for realtor membership. So if someone actually does qualify for realtor membership, they can't join as an affiliate member. They need to join as a realtor member. Section 8 talks about the membership application process. And this is not one that is required to be adopted verbatim. However, if you are doing a different application process than the one that we have in the model local bylaws, then you should probably actually change your bylaws to reflect how you're handling the membership application process. Just to kind of go briefly through how the application process works in the local bylaws, every applicant for membership has to submit an application, basically in the form that's approved by the board of directors. And then the board of directors, through its membership committee or otherwise, may consider the following in determining qualifications for membership. And then there's a list of all these things that you would consider: code of ethics violations, pending ethics complaints, unsatisfied discipline, arbitration requests or hearings, and unpaid arbitration awards. B talks about how applicants for membership have to be familiar and agree to abide by the bylaws and rules of the association. Applicants also have to complete an orientation program as required by the board of directors. And an applicant will be eligible only for the status of provisional membership until that mandatory orientation is satisfied. Anyone who is applying for realtor membership must certify that they have no record of official sanctions rendered by the courts or lawful authorities for violations of civil rights laws or real estate license laws. This is basically the same criteria that we talked about in terms of criminal convictions that would bar you from being a realtor. You have to certify that you don't have any of those kinds of criminal convictions, and also that you haven't been suspended or expelled from an association for the past 3 years for violations of the code of ethics. And then certain things that applicants who are realtor principals have to disclose. Section 9 talks about prior membership records. So this is when we talk about, letters of good standing that need to be sent, because the association is going to look for information from prior associations that this applicant belonged to get information about prior code of ethics violations, any pending complaints. Another thing that you can use is the ethics check system, but you're usually going to want to back that up with actually contacting any prior associations that they belong to for that letter of good standing. There's a note here, an important one, that the NAR bylaws prohibits a member association from knowingly granting realtor membership to any applicant who has an unfulfilled sanction pending, which was imposed by another association for violation of the code, whether learned through C.A.R. ethics check or otherwise. Section 10 is the process for application review and acceptance. In the interest of time, I'm not going to go through this in a lot of detail, but there's basically a procedure where if someone is rejected from membership, they have the right to appeal it and get a review by the board of directors. Again, this is not required to be adopted verbatim, so you could have a different process, but most associations use the process here. Section 11 is required. All members have to take a new member code of ethics orientation. A requirement does not apply to applicants for realtor membership or provisional members who completed comparable orientation in another association, provided that their realtor membership was continuous or that any break in membership was for 1 year or less. Failure to satisfy that requirement within blank days, so you have the option of deciding how soon that requirement has to be fulfilled, will result in the denial of the membership application or termination of provisional membership. And then we have the continuing member code of ethics training, which is also an NAR requirement. It's a 3-year requirement that members have to take this code of ethics training. The next period where the compliance deadline will hit is at the end of 2024. Failure to satisfy that requirement is considered to be a violation of a membership duty and results in suspension of membership for the first 2 months of the year following the end of any 3-year cycle. On March 1st of that year, the membership of the member who is still suspended will actually be automatically terminated. Section 13 has to do with status changes. So realtors who change the conditions under which they hold membership are required to provide written notification to the association within 30 days. So for example, a non-principal who becomes a principal in the firm has to notify the association of that change in status. If the license status of any member is terminated, his or her membership in the association will be subject to immediate termination. C says any application fee related to a change in membership status will be reduced by an amount equal to any application fee previously paid by the applicant. And dues are prorated from the first day of the month in which the member is notified of this change in status. Section 14 has to do with resignation. Resignation of members become effective when received in writing by the board, provided that if any member submitting the resignation is indebted to the association for dues, fees, fines, or other assessments, the association may condition the right of the resigning member to reapply for membership upon payment in full of all those monies that are owed. So that brings us to the end of Section 5, membership section. It's a big one, but very important things to remember in those sections. Article 6 has to do with the privileges and duties of membership. Most of the sections in this portion of the bylaws require verbatim adoption by member associations. I'm not going to go through what these say word for word, but basically members have to comply with the bylaws, policies, rules, and regulations of the association, and members have to maintain a high level of integrity. Although only realtor members are subject to the code of ethics, we make it clear that all members are encouraged to abide by the principles established in the code of ethics and have to conduct their business and professional practices accordingly. Section 2 has to do with member discipline. Part A has to do with the fact that a member can be disciplined by the board of directors for violations of the code of ethics and other membership duties. And that is set forth in the California Code of Ethics and Arbitration Manual, the procedures that govern those hearings. Obviously too big of a subject to cover on today's call, but if any of you are interested in more pro standards, I do a lot of that stuff. So there will be training on that actually next week for any of you who need training to be professional standards administrator. For anyone who does need that PSA training, you can sign up for it on the C.A.R. website. It will be 2 days, 3 hours each day of training on Tuesday and Wednesday next week. Additionally, any member of the association may be reprimanded, placed on probation, suspended, expelled, or removed from office for violating the association's anti-harassment policy. So this separate anti-harassment policy is a relatively recent change that we made to the bylaws. Some of you may have older bylaws where we talk about the prohibition on harassment in the bylaws themselves. But whether you have it in your bylaws or you adopted this separate anti-harassment policy as NAR recommends and as we've put in the model local bylaws, this is a separate process for disciplining a member who has done something to harass association staff or harass association leadership or has done something harassing at an association event. These are ways that you can discipline someone apart from the code of ethics. Section 3 talks about resignation with pending arbitration or disciplinary hearing. Basically, it says that if a member resigns from the association or causes membership to terminate with a disciplinary complaint pending, that complaint will be processed until the decision of the association with respect to the disposition of the complaint is final by this association or by any other association where the respondent continues to hold membership. And if the ethics respondent resigns or otherwise causes membership in all associations to terminate before an ethics complaint is filed, then the complaint will be processed until the decision of the association with respect to the disposition of the complaint is final. If there's an ethics hearing held subsequent to an ethics respondent's resignation or membership termination, any discipline is held in abeyance until the respondent rejoins an association. But we want to make it clear that even if someone has resigned, the disciplinary hearing still should move forward, and the board of directors should ratify it, but hold any discipline in abeyance until that person does actually rejoin an association, if in fact they do so. Section 4, voting rights and eligibility for elective office. When we make it clear, only realtor members, whether primary or secondary in good standing, are entitled to vote and hold elective office in the association. And then we actually define this as a new thing that was added by NAR. The term good standing means that the member satisfies the obligations of realtor members set forth in Article 6, Section 1, is current with all financial and disciplinary obligations to the association and MLS, has completed any new member requirements, and complies with NAR's trademark rules. So when we're talking about good standing, it is actually now defined in the bylaws. Previously, it was not. So I'm glad that NAR made this change. So now we actually know specifically what good standing means. Section 5 talks about the privileges and duties of realtor membership. Duty that realtors have to abide by the code of ethics and the bylaws of NAR. They have the primary responsibility to safeguard and promote the standards, interests, and welfare of the association and the real estate profession. They're allowed to use the term realtor and realtors, subject to the provisions in Article 8. D talks about the fact if a realtor member who is a realtor principal is suspended or expelled, his or her firm, partnership, or corporation shall not use the term realtor or realtors in connection with its business during the period of suspension or expulsion, unless the disciplined member severs his or her connection with the firm or the disciplined member relinquishes management control. So that's important to remember in situations where a realtor principal is actually suspended or expelled. The firm is going to have to take steps so that they and the rest of their members are allowed to continue to use the term realtor. Okay. Let's move on. Privileges and duties of these other types of members. Basically, it's whatever is set by the board of directors. So there's not much in the model local bylaws about that. Section 11 has to do with certification by the designated realtor. They shall certify to the association during the first month of each fiscal year on a form provided by the association a complete listing of all individuals licensed or certified under California law with the realtor firm, and shall designate the primary association, if any, for each individual. And that's used for the purpose, of course, of calculating dues and assessments, which we'll talk about very soon. Article 7 covers professional standards and arbitration. This does require verbatim adoption. And it basically says the responsibility of the association and its members relating to the enforcement of the Code of Ethics is going to be governed by the California Code of Ethics and Arbitration Manual as published by C.A.R. Section 2 says member compliance with NAR and C.A.R, Constitution, bylaws, policies, rules, regulations, and the Code of Ethics. Basically, all members have a duty to comply with those things. Article 8. This governs the use of the term realtor and realtors. And of course, this requires verbatim adoption by member associations because realtor is an NAR trademark, and they are very strict about how members are allowed to use the mark. Section 1 talks about how use of the terms realtor and realtors by members are at all times subject to NAR policy. Any misuse of the term realtor and realtors is a violation of a membership duty and can subject the member to disciplinary action. Section 2 talks about jurisdictional limits on the use of the realtor membership marks. They have the privilege, and the members of the association have the privilege of using the term realtors and realtor and realtors in connection with their places of business within California or a state contiguous thereto, so long as they remain realtor members in good standing. No other class of members can use that term, only realtor members. Use of the realtor membership marks is dependent on the status of firm principals. We talked about that earlier. Section 4, institute affiliate members are ineligible to use realtor membership marks, so only realtor members can use them. All right, Article 9, this is a big one, talking about dues and assessments. Sections 1 and 2 require verbatim adoption, and Section 2 is quite long. It has a lot of sections to it, and basically talks about the whole dues and assessment process. Section 1 talks about the application fee. The board is allowed to adopt a reasonable application fee for membership in the association. And the application for that cannot exceed 3 times the amount of annual dues for realtor membership. I don't think most associations have an application fee that high. The application fee shall be required to accompany each application for membership in the association, and the association collects all C.A.R. and NAR new member application fees, if any. All right, Section 2 is the big one. This is one where it really governs how the association assesses dues to its members. The board determines annually the amount of dues and assessments to be paid by each class of membership, and then B, the dues and assessments of each designated realtor member are a base amount plus an amount multiplied by the number of real estate licensees and licensed or certified appraisers under California law to which he or she is certified under Article 6, Section 11, and who are, number 1, employed by or affiliated as independent contractors or who are otherwise directly or indirectly licensed or certified with such realtor member, and number 2, are not realtor members of any association within California or a state contiguous thereto, or institute affiliate members of the association. This is basically the office size formula, where designated realtors are required to pay dues for non-member salespeople. This is where that rule comes from. So if anyone ever asks you the source of your authority to charge them for that, you can point them to this section of the bylaws. In calculating the dues and assessments payable to the AOR by a designated realtor, non-member licensees are defined in paragraphs or sections 1 and 2 of the subparagraph, not included in the computation of dues and assessments if the DR is paid dues and assessments based on non-member licensees to another association in California or state contiguous thereto, provided the DR notifies the AOR of the identity of the association in which those dues and assessments were remitted. There's an affirmative duty of the DR to keep dues and assessments formulations current and accurate, and to notify the association within 30 days of any changes. Section D talks about everyone's favorite exception, the LIFRO exception. So realtors who have a direct or indirect interest in an entity engaged exclusively in soliciting and or referring clients and customers to the realtor for consideration on a substantially exclusive basis, those are defined as LIFROs, limited function referral only agents, shall annually file with the association on a form approved by the association that all of the licensees affiliated with that entity are just engaged in referring clients and are not engaged in any other real estate licensed activities. And that exempts the designated realtor from having to pay dues for those particular agents. Now keep in mind this last part here, it's considered a violation of a membership duty for a realtor to falsely certify LIFRO status. So if you determine that someone is falsely certified an agent as a LIFRO, you can go after them and have a disciplinary hearing against them. Moreover, the exemption for any licensee included on a certification form for a LIFRO is automatically revoked upon the individual being engaged in the real estate profession as we defined it here. And if it's revoked, they're not allowed to reapply for the LIFRO exemption until the following fiscal year. There's also a similar exemption. This one doesn't get quite as much traction for people who are mortgage loan originators. So if the designated realtor has a separate entity with agents who are just mortgage loan originators and are not participants or subscribers in any MLS, then those people are also exempt from the dues calculation formula. We have a question here in chat. Can a LIFRO advertise listings on their website for referring out? Can a LIFRO advertise for referring out? They're advertising other people's listings. I'm not sure I understand. Well, if they had the permission to advertise other people's listings, I guess they would have the ability to do that. Yeah, if they were given the proper permission, I think that's fine. Okay, F, membership dues and assessments are prorated for any licensee included on a certification form. However, membership dues and assessments are not prorated if the licensee held realtor membership during the preceding calendar year. The annual dues and assessments of realtor members do not include any allocation for NAR if the member, oops, I think this one. So C.A.R. talks about the allocation for C.A.R. and NAR. In the case of a designated realtor member in a firm, partnership, or corporation whose business activity is substantially all commercial, any assessments for non-member licensees are limited to licensees affiliated with the DR in the residential non-commercial office. Okay, dues and assessments of institute affiliate members are established by NAR. Section 3 talks about dues and assessments being payable. So we're now in a part that does not require verbatim adoption. So you don't have to do it this way, but I think most associations do. Dues and assessments for all members are payable annually in advance on the first day of January. And they're computed from the first day of the month in which a new member is notified of acceptance and prorated for the remainder of the year. Any member who initiates bankruptcy proceedings, okay, we don't need to go over that. And they're non-refundable, except for those returned to a terminated provisional member. Okay, adjustments, that's all fine. So section 4 talks about the process for handling non-payment of financial obligations. And I don't want to go over all of this. This is not required to be adopted verbatim. But the payment timeframes in this revised model have been condensed to make the broker compliance tool compliance easier. So local associations can use different timeframes, but it may be harder to comply with the BCT if you're using different timeframes than the ones that we have here. Basically, if the fees are not paid within 1 month after due date, the non-paying member is subject to suspension. 2 months after due date, the member should be automatically terminated. The member can request a hearing, and you can go through a whole hearing process. Hopefully you don't have to do that very often. So section 5 is about reinstatement after termination of non-payment of financial obligations. So a former member who has had his or her membership terminated for non-payment of dues, fees, fines, or other assessments may apply for reinstatement in a manner prescribed for new applicants for membership only upon making full payment of all past due accounts, together with an interest at the rate of 10% per annum. So they have to pay everything that they owe before they're able to reapply. Financial institution, that's pretty straightforward in section 6. Section 7 is about notice of delinquent dues, fees, fines, assessments, and other financial obligations of members. They'll have to be served in writing, including by electronic means. All right, now we're at Article 10, and this is an important one because it governs the composition of your association leadership, the officers and directors. Note that there's nothing in the remainder of these model local bylaws that requires verbatim adoption, including this section. So what we have in the model local bylaws are proposed criteria And it includes prerequisites for being an officer and director. Again, you don't have to have prerequisites, but we highly recommend that you do that. But whatever your prerequisites are, they have to make sense for your association. Basically, for the officers, the composition is usually going to be a president, president-elect, secretary, and treasurer. The offices of the secretary and treasurer can be held by the same person, but otherwise no two people should hold the same office. And then the president-elect automatically ascends to the presidency at the end of his or her term as president-elect, unless for some reason they're stripped of that office. The executive officer is the chief staff person of the association, but is not an officer or member of the board of directors. Essentially, the executive officer is hired by the board of directors. Criteria for being an officer of the association. There's a lot of blanks here because you can basically fill these in with whatever you think is appropriate for your local association. But basically, it's about experience, and you should probably have at least some criteria. Term of office, president and president-elect, we recommend they serve one-year terms. Again, that's not a requirement, but it is usually what most associations do. And then the secretary and treasurer can actually serve a longer term if you want, but they can also serve one-year terms. The powers and duties of officers are basically whatever is assigned to them by the board of directors. Bylaws don't say any more than that. And then Section 3 governs the composition and criteria for being a member of the board of directors. So the governing body of the association is the board of directors, consists of all the elected officers. Usually the immediate past president of the board will be a member of the board of directors as well. Not elected by the members, but serves by designation of the fact that they were the president previously. And then a certain number of elected realtor members of the association. We don't put a certain number in the local bylaws. You can decide how many elected directors you want. All directors, including the elected officers and immediate past president, have one vote. And not more than blank directors from any one office or multi-office firm under the same ownership shall serve on the board at any one time. Again, you don't need to have this, but I think a lot of associations like to make sure that the board is not dominated by any one firm. And so it's probably good to have a provision like this. Any director who transfers his or her license to an office or multi-office company which has a maximum directors allowed automatically resigns as a director on the date of his or her transfer. And then we have the criteria for being a director, a number of years as a member you could require. You want to make sure that their financial obligations are paid in full. They have to have sound professional character. Again, these are the criteria we recommend. You don't have to have this in your bylaws. I highly recommend that you do. And then honor fiduciary duties to the A.R. and meet other requirements as may be established. Usually, we recommend the elected directors serve for terms of 2 years with staggered terms. The term of the immediate past president is usually going to be 1 year, and thereafter as many directors shall be elected each year as required to fill the vacancies. No person may serve in a particular capacity on the board for more than blank consecutive terms. If you're a smaller association and you have a hard time recruiting directors, maybe you don't want this one. And you don't necessarily need a bar on a certain number of consecutive terms. But for other associations, you might want a certain amount of turnover and make sure that you're keeping the leadership fresh. So it might be good to put a limit on the number of consecutive terms. The president may serve no more than 1 term consecutively, but is not precluded from future service if reelected. All right, powers and duties of the board, basically governed by California nonprofit law and any limitations on the articles of incorporation. But basically, the board of directors governs the management of the association, and they can delegate certain tasks to others. For example, the board of directors delegates a lot of the day-to-day tasks of running the association to the executive officer, the association executive. Section 5 governs the election of officers and directors, common one that I will get questions about. Again, these are just recommendations for how to handle elections, but the best practices that we have in the model local bylaws have worked well for most associations. So highly recommend that you at least take a look at what's in the model local bylaws and consider whether you want to include C.A.R.'s model language rather than what you have right now. But again, if you want to make modifications for local conditions, you can do that. Talks about delivery of notices. B is important, a nominating committee. So most associations do it this way. About 2 months before the annual election, there's a nominating committee of a certain number of realtor members appointed by the president with the approval of the board, and the nominating committee selects one candidate for each office and one candidate for each place to be filled on the board. Of course, no member of the nominating committee can be a candidate for office or the board, and no person may be nominated for office unless they meet all the qualifications that we listed above. Once the nominating committee has selected the slate of nominees, it may share it with the board of directors for information only. However, the board can't override, revise, or approve the slate. So this is one I've got a couple of calls about this before. The board does not get to reject the slate itself. It gets shared with them, but it's not up to the board to say, you know what, we actually don't like this slate. We're going to overrule you. The report of the nominating committee shall be delivered to each member eligible to vote at least 4 weeks preceding the election. Besides the nominating committee, additional candidates for office can be filled by nomination by petition. That petition has to be signed by at least 25% of the realtor members eligible to vote. So it's a pretty high bar to clear, but people can do it. The petition is then filed with the secretary at least 3 weeks before the election, and the petition will contain a statement signed by the candidate that they meet the qualifications. Then the election committee will be formed by the president with the approval of the board of directors. No member of the election committee can actually be a candidate. Seems fair. In lieu of a separately appointed election committee, the president with the approval of the board may appoint the nominating committee to act as the election committee. And the election committee will set a date on or before the annual meeting on which the elections were held. And the elections are by a ballot delivered to the members, and the ballot will contain the names of all candidates and specify the office that they're nominated for. Ballots are submitted by the members by mail and or in person. Right now, probably most are doing it online, or by another method as determined by the board of directors. The candidate receiving the highest number of votes are elected, like a usual election. There's one additional thing that you can do. If you have an election where there are no candidate challenges, where you only have one candidate for each office, rather than actually holding an election, you can do what's called an election by acclamation. But you have to make sure that you've included this in your bylaws before you do it. It's in the model bylaws, but it's something that we added relatively recently. So if you haven't updated your own bylaws in a while, you may not have it in your own local bylaws. But, I recommend including it. In the event the time for nomination by petition is passed and the number of people nominated for the board is not more than the number of directors, which each and every director seat up for vote remaining uncontested, and that also applies to, officers as well, who are members of the board of directors. In its discretion, the board of directors may authorize a vote by acclamation and without further action, declare that those nominated and qualified to be elected have been elected. So the board just passes a motion saying this election is by acclamation and everyone who is nominated becomes elected. That you can only do that if you don't have any challengers. The moment that there's someone who is challenging for any of the offices, then you can't have an election by acclamation. Vacancies. So vacancies among the officers and the board of directors are filled by an act of the board of directors until the next annual election. So if an officer or director is unable to assume office after being elected, his or her seat becomes vacant and is going to be filled by the board of directors. So it's basically the board votes to fill any vacancies. There are ways that you can remove officers and directors. Removal by the board for cause. And this lists the various reasons that the board can remove someone from the board of directors. They can also be removed by the board for a violation of the NAR Code of Ethics or other membership duty. That's going to be subject to review by the association's board of directors as to the severity of the violation, based solely on the final findings of fact and appropriateness of removal for office. So violating the Code of Ethics is not an automatic reason to remove someone from a position, but the board should at least review it and determine whether that might be appropriate. Also, the membership can remove someone as an officer or director, but that's pretty hard to do. There needs to be a petition that is signed by not less than 1/3 of the voting membership or majority of directors. Upon receipt of the petition, there's a special meeting of the voting membership that has to be held. And then the special meeting, provided a quorum is present, 3/4 vote of the members present has to be required for removal from office. So it's a pretty high bar to remove someone. You don't see it happen very often. In chat, if the board of directors fills a vacant seat, does the new officer need to apply at the next election? Yes, they do, because the vacancy is only for the remainder of the term. So now I should scratch that. If someone has a term that's longer than 1 year, then they wouldn't need to reapply at the next election. But whenever the term ends, they would need to be up for election again. All right, and then section 8, the board of directors shall administer the day-to-day finances of the association. Unbudgeted capital expenditures in excess of blank, so you can decide how much that's going to be, may not be made unless authorized by a majority of the association members eligible to vote and present at a duly held membership meeting. However, unbudgeted expenditures required for the protection of capital assets or to respond to emergency situations can be incurred by the board without the prior approval of the full membership of the association. Capital expenditures are those expenditures for long-term improvements chargeable to the capital asset. So I'm running a little long. It's all right, Peggy, if I go a little long here. I think I have maybe like 10 to 15 more minutes.
Absolutely, Brian. And anybody who needs to duck out can catch it on the recording. Sure.
Yeah, I haven't done this exact training before, so I wasn't sure exactly how long it would take. But so I apologize everyone for running a bit long here, but I think there's some good information. But we're definitely done with most of the model bylaws by this point. Article 11 addresses meetings. These sections were recently revised to offer greater flexibility and detail regarding how meetings are scheduled and conducted. So take a look at your own local bylaws, see if you have adopted the model local bylaws on this score. And if you haven't, you might want to consider making a change to your model local bylaws on the way meetings are conducted. Section 1, annual meetings. The annual meeting of the association will be held during blank of each year, so you can decide when the annual meeting, with the date, hour, manner, and place to be designated by the board of directors. Meetings of directors. The board of directors shall designate a regular time, manner, and place of meetings. Regular meetings can be held without notice as long as the time and place are fixed by the board. Special meetings of the board, however, may also be called by the president, secretary, or any 2 directors in accordance with the notice provisions set forth. In addition to actual in-person meetings, directors can participate in the meeting through the use of conference, telephone, electronic video screen communication, or electronic transmission by and to the association, by means of which all persons participating in the meeting can communicate with each other simultaneously. It's a long way of saying you can have a board of directors meeting by Zoom. Now, one thing to keep in mind, and this is a question I get occasionally, you can't have a board of directors vote solely by email, except in rare circumstances that I'll get to in a moment, because that is not an actual board of directors meeting, because all people are not able to communicate simultaneously. It's not an actual board of directors meeting where you can vote unless you have that simultaneous communication. Meetings of the members. So meetings of the members can be held at other times as the president or board may determine, or upon the written request of at least 50% of the members eligible to vote. Doesn't happen very often. The board of directors may designate that a meeting of the members may be conducted by electronic transmission, so same as for a board meeting. Participation in such meetings shall constitute presence in person at the meeting. Okay, so that's all the same as for directors. So notice of meetings. Written notice of membership meetings. So in chat, is it not the same as when C.A.R. meetings were held with votes via Zoom during COVID? Yeah, kind of the same idea. The C.A.R. Board of Directors meeting was held virtually during the COVID times. Notice of meetings. So written notice of membership meetings stating the date, time, place, and or means of electronic transmission by the association and the purpose of the meeting are delivered personally by first-class mail. Usually it's going to be by email, which is listed here. You want to make sure that your bylaws allow for email notices. At the current A.R. records of every member entitled to participate in the meeting, at least 20, but not more than 90 calendar days preceding all meetings. The association may also publish a notice of membership meetings in any publication regularly sent to all members of the association. If the special meeting is called, it needs to be accompanied by a statement of the purpose of the meeting. For board of directors meetings, there's also a notice requirement. It can be done by email. In the case the notice is delivered personally, should Okay, it needs to be delivered 48 hours before the time of the holding of the meeting. Waiver of notice. So the transactions of any meeting of the board of directors, however called and noticed or wherever held, shall be valid as though a meeting had been duly held after regular call and notice if a quorum is present, and if either before or after the meeting, each of the directors not present signs a waiver of notice, a consent to holding the meeting on approval of the minutes. So I don't recommend doing it this way. It's better to get the notice out appropriately rather than going down this waiver of notice route. But it is a possibility to do it if you realize that you didn't get out the notice properly in advance of the meeting. Section 5 has to do with quorum. A quorum for the transaction of business by the general membership shall consist of 1/3 of the voting power. Remember, this is a default number. You don't have to do 1/3. Lawfully, you can designate a lesser amount as long as you're adhering to the general meeting notice time frames. So basically, a quorum allows you to transact business. A quorum for the transaction of business by the board of directors shall consist of 51% of the directors. So here's where I was talking about actions that you can take without a meeting. So there are some circumstances where you can have a vote without a meeting, but it's rare. So for membership meetings, any action that may be taken at any regular membership meeting or special membership meeting may be taken without a meeting if the association distributes a written or electronic ballot to every member entitled to vote on the matter. Approval by written or electronic ballots is only valid when the number of votes cast by ballot within the time period specified equals or exceeds the quorum required to be present at a meeting authorizing the action, and the number of approvals equals or exceeds the number of votes that would be required to approve such action at a meeting had the vote been taken in a face-to-face meeting. So you can do a membership vote without a meeting, but you have to get enough people to vote, otherwise it's not valid. So that can be an uphill climb sometimes. For a board of directors meeting, any action that may be taken by the board may be taken without a meeting if all the directors individually or collectively consent in writing to that action, and that requires unanimous consent. So if you are ever going to have an email vote by the directors, you can do it, but the directors have to be 100% in agreement in whatever you are voting on. If there is a single dissenting director, there has to be a meeting to take that vote. The written consent shall be filed with the corporate records or made part of the minutes of the meeting. The action by written consent shall have the same force and effect as a unanimous vote of the directors. So that is the only way the directors can act without all being present in a Zoom or live meeting. Article 12 governs committees. Once again, doesn't require verbatim adoption here, although most associations are going to have the committees that we list here. The president shall appoint from among the Realtor members, subject to confirmation by the board, the following standing committees. Nominating committee, as we recommend for handling elections. Also the election committee, unless that's waived by the board. Grievance and professional standards committees, unless you're a smaller board and you farm out your administration of pro standards to a different association. But most local associations will have grievance and pro standards committees. And a multiple listing service committee, unless the association doesn't operate or service an MLS. Section 2 has to do with discretionary committees. You can include different ones than the ones that we list here, but these are kind of some of the standard ones. The president may appoint from among the Realtor members, subject to confirmation by the board, any of these additional committees. And then section 3 is about task forces or work groups. And the president can appoint from among the Realtor members people for those things. Term of committee appointments. The committee members shall be appointed to 1-year terms, except that the members of grievance, long-range planning, and professional standards committees shall be appointed to staggered 3-year terms. For organization, all committees shall be of such size and shall have duties, functions, and powers assigned by the board. So basically, the board decides what each committee does. It's not really included in the bylaws. The definitions of the committees are not included in the bylaws themselves. I'm seeing in chat someone says, we struggle with the definition of a standing committee. Is it a policymaking committee? No, the definition of a standing committee simply means that it's a committee that is always in effect. Pursuant to the bylaws, that committee always has to exist. It doesn't mean a policymaking committee. Policymaking committees are policymaking committees, the ones that make policy, but it's not the same as the definition of a standing committee. Section 6, the president shall be a non-voting member of all standing committees and shall be notified of their meetings. So the president always has a right to attend a committee meeting. The president shall have the power, subject to confirmation by the board of directors, to remove any member from a committee. So the president has a lot of power over the committees. They basically appoint members of the committees and they have the power to remove them as long as the board agrees with that. Article 13, this is pretty straightforward. Fiscal and elective year. We recommend that the fiscal year be January 1st through December 31st. The elective year, however, is usually going to begin the day following the official closing of the NAR annual convention and end the last day of the NAR convention for the following year. So it actually allows people who are elected to get a jump start before the calendar year actually shifts over. Does the president count towards quorum? Well, they're a non-voting member, so they would not count towards the quorum. Except, I'm sorry, if were we talking about committees or the board of directors? Because on the board of directors, the president does have the right to vote. So they would count towards the quorum for that. Oh yeah, for committees. Yeah, no, they would not. Article 14, basically you want to follow Robert's Rules of Order, latest edition. You want more on that? I did a whole AE 101 seminar on Robert's Rules of Order, so check that out. Article 15 on amendments. This is what I kind of referred to a little earlier here. The amendment process set forth below was recently revised to offer greater flexibility. So you'll want to check your own local bylaws to see if you have this amendment process, because if you don't, it makes amending the bylaws a little more difficult. So here's what the amendment process is in the model. A, it can be done by a majority vote of the membership. That's the hard way. But B, it can be done by a majority vote of the board, because the board of directors may, at any regular or special meeting of the board of directors at which quorum is present, approve amendments to the bylaws which are mandated by NAR policy or that are set forth in the C.A.R. model bylaws or as otherwise permitted in the California Corporations Code. So this gives the board of directors wide latitude to make a lot of changes to the bylaws by their own vote. If it's something in the C.A.R. model bylaws, the board of directors can do it. Or if it's something that's just permitted by the California Corporations Code, the board of directors are allowed to do it on their own. But that's only if you haven't adopted this section of the C.A.R. model local bylaws. Older versions do not give the board this wide range of authority to make changes to the bylaws. Any notice of meetings which amendments are to be considered shall be delivered personally, by fax, email, regular mail, at least 20 calendar days prior. Approval and amendments by NAR. Any amendments to the bylaws affecting the admission or qualification of Realtor and Institute affiliate members, the use of the term Realtor and Realtors, or any alteration in the territorial jurisdiction of the association can be effective upon their approval as authorized by the board. So that does not require the membership. Article 16. Someone asked, what's the part in green? Any amendment that would materially and adversely affect the rights of members as to voting, dissolution, redemption or transfer, alter or impact the number of members or membership class, alter the number of or increase the term of director seats, increase the quorum, alter proxy rights. So all these lists of things in accordance with the California Corporations Code actually do require approval by a vote of the membership. So even if you have made a change to the model bylaws to allow the board of directors to make changes by their own vote, if you're making a change that affects any of these things that's listed in this note, then you still do need a vote of the membership to make a change to the bylaws on those matters. So thanks, Kim, for pointing that out. I skipped over that, but that is pretty important. There are certain amendments that still do require a vote of the membership. Article 16, dissolution. This talks about what happens if the association dissolves for whatever reason. And I feel like it doesn't happen very often, but I have heard of a few smaller associations dissolving. So a lot of times they'll merge with another association rather than dissolving, but you can just dissolve an association as well. Upon the dissolution of this association, the board, after providing for the payment of all obligations, can distribute any remaining assets to C.A.R. or within its discretion to any other nonprofit tax-exempt organization. And then Article 17, if you have a multiple listing service, it's good to have these sections as well, that you have MLS rules that govern the use of the MLS. The purpose of the multiple listing service basically goes over that you have an MLS committee All members of the committee will be MLS participants or subscribers, and the actions of the MLS committee are subject to approval by the board. And then section 4 talks about access to comparable and statistical information that members have the right to have, provided the MLS generates such publications. And that basically is everything that's in the model local bylaws. We covered everything in the bylaws. So now you're experts on it. You know everything that's in the bylaws. The important thing is just to kind of know what's in the bylaws, so that if anyone ever asks you a question and you're like, is that something that's covered by the bylaws? You just kind of remember, you know what, I think that is in the bylaws. So let me open up my bylaws and take a look to see what my bylaws say about that. Anything related to membership criteria is going to be in the bylaws. Anything related to dues, the dues formula, the dues payments, anything related to the election of officers and directors is going to be in the bylaws. So all of that is governed by your bylaws. So I think that basically covers it. Any more questions for me before we finish?
If anyone has any questions, you can just unmute and ask Brian.
I have a question, Brian. Back to Article 6, Section 11, where it was that designated realtors shall certify to the A.O.R. during the first month of the fiscal year on a form provided by the A.O.R. a complete listing of all individuals licensed or certified, basically with them. Does C.A.R. provide that form for us, or do we create it?
I think the membership department provides that form, but I'm not familiar with the specifics of that.
Okay.
I mean, the C.A.R. membership department. I think there is one, but I'm not sure.
And I'm a little confused if the fiscal year starts at the beginning of January and dues are supposed to be paid in advance of the first day of January, but we're asking them to certify after we've already assessed dues, their roster, basically. Does that seem backwards to you, or I'm left-handed, so it might be backwards to me, and I'm fine with that.
Yeah, I don't actually know the justification for having the fiscal year just be the calendar year, but I think that's just kind of the default. But if for whatever reason you would want a fiscal year to be different than that, you could, because that doesn't require verbatim adoption.
No, I don't want to change our fiscal year. I just want to make sure that if I'm going to ask them who's licensed, that I'm doing it for the reason to assess the dues. Okay, thanks.
Sure.
Anybody else? Well, Brian, that was a ton of information, and I'm going to be honest with you, there are things that I didn't know, and quite frankly, things that we may have been doing wrong for a while. So that was really terrific. I would recommend to everybody that when you get the follow-up email that you take a look at this one more time with your own bylaws in front of you, because I think that will put it into your own perspective. So thanks everybody for staying on. Brian, thank you so much for this amazing education. Somebody had asked about the slides. There won't be any because those weren't slides. That was the actual model bylaws, but I will send you a link in the follow-up to the model bylaws.
Yeah, I mean, I recommend that everyone actually read through the entirety of the model local bylaws on their own and compare them to your own local bylaws, like Peggy said. I think that's a really useful exercise. And you can see various ways that maybe your own bylaws could be improved. Because I know a lot of times local associations miss changes that we've made to the bylaws over the years, and then they get stuck with older, outdated language that we've improved upon.